You're listening to the Royal Palace Podcast, the podcast where we explain French law to Americans. Welcome back. I'm Liam, and I'm here with your co-host, Patrick. How's it going, Patrick?
Howdy.
So, what did you want to talk about today?
So, I've been listening lately to Opening Arguments. It's a podcast about the law as well. Right now, they're doing the Trump trial, actually.
Which one? Isn't he on trial for like 50 things? I mean, I haven't been paying that much attention, but he's on trial for like the Stormy Daniels hush money thing, and then
Correct. Yeah, there's a lot of stuff too, right? A lot of great stuff in there, and they're making it so much more enjoyable because instead of just reading the transcript, they got voice actors. And so in order to relive some of the best moments of the trial, they're recording it, they're acting it. It's awesome.
That's fun. I'll have to check that out. Our listeners may be surprised to hear that Patrick listens to many more legal podcasts than I do.
Oh, did you listen to the new episode of A-Lab?
Oh, they released that. I saw that on Twitter the past couple of weeks. They kept announcing it, but everyone seemed to think they were just trolling and we're not actually going to release an episode.
You know, as they admit themselves, it might not be the most researched of episodes they've done, but they've decided that recording is better than not recording.
Wow. Exciting things happening in the world of legal podcasts. And here's one more exciting thing. Don't know when people are going to be listening to this, but hopefully at some point.
So Liam, on Opening Arguments, they once a week ask Thomas, who's the non-lawyer on the podcast, to answer a bar question. And so they do this from a bar practice book. On one episode, Thomas is asked the bar question, and then he on the spot has to give an answer. And then they give a week or until the next episode for listeners to write in on Twitter or on Reddit their answer to the question. And then they reveal the answer. And I was kind of thinking that what we could do is we could kind of work through this, but from a French law perspective. Given the facts, sort of speculate what the answer would be in French law. And through that, we could sort of see some of the differences between how things work in the United States versus in France.
Okay, sounds good. It's interesting. And by the way, I'm glad to hear that I'm not the only non-lawyer co-host of a legal podcast.
I'm also a non-lawyer host of a legal podcast.
That's true. We may be the only legal podcast hosted by two people who aren't lawyers. So that's our selling point, really. Don't trust anything we say.
So how about we start by, I'll read you the question.
Okay.
Without giving you the multiple choice answers, I just want your kind of initial reaction.
Okay.
Then I'll present to you the multiple choice answers.
Okay.
And we can get into the details.
So this is a real question from the multi-state bar in the US?
It's a real practice question. So I don't know if it's ever actually appeared on the bar, but it's in the, it's in the same logic.
And so if I get this right, I should probably just take the bar. Not bother with law school, just go straight to the bar.
I mean, if you can go through one of the very few ways of doing that, sure.
Wait, hold on, one more question. Is this a real case?
You're going to need real case law in order to solve it. So
I'll rack my brain for some of that.
So the question reads: Jack owns a large fish farm and keeps several different species, including a type of fish known for its aggressive behavior.
What species? They don't mention the species?
No.
Actually, they wanted to keep that anonymous. They don't want to slander any particular type of fish.
One day, a group of divers enters the property without permission and is attacked by the aggressive fish, resulting in injuries. The divers sue Jack under strict liability for injuries. How will the court likely rule? So, off the cuff, what do you think?
So, a group of divers breaks into his property.
Yep.
Right. So I would say they probably do have some sort of case, right? Because I know that, like, if someone broke into your home and then hurt themselves, which is kind of the same thing, if they fell down your stairs because your stairs were slippery and unsafe, could they sue you? One thing that immediately jumps out to me is obviously they were committing a crime, but I feel like that's kind of a trick there, where that people would you would maybe think, if you don't know much about the law, that because they were committing a crime, they'd have no case to sue him for something that happened while they were trespassing on his property. But I definitely know that's not true.
What would be, for example, a concrete example where it would be absurd for there to be absolutely no recourse while you're doing something that's technically illegal?
Well, the classic thing I would think of is the classic thing stupid guys in the U.S. think, which is that if someone breaks into your property, you can legally just kill them, and that's completely justified.
But what about is there legitimate reasons one would trespass, for example?
Oh, interesting. Yeah, I guess the question doesn't actually say that they're trespassing in order to commit theft or anything like that. Yeah, you could definitely be trespassing because you're, I don't know, running away from imminent danger, something like that. I also know that trespassing is I believe a misdemeanor. I think it's not even considered like a crime, although I don't really understand that distinction, to be honest.
So that's actually an interesting thing, because trespassing can be, as far as I understand it, two things. One, it's a tort. So there's the tort of trespass.
Right.
And then there can also be criminal sanctions for trespassing.
But it's generally considered a pretty minor crime or tort, right? So a tort, it's not even a crime. With a burglary, the main thing you've done, the main crime you've committed is not the trespassing. It's the property damage, breaking and entering, the theft. So yeah, I guess now that you say that, there are definitely reasons that you could, well, I don't know if those are legally considered legitimate, but definitely just intuitively it feels legitimate that someone could have been running away from a fire or something like that.
As you said earlier, what if someone's chasing you, like a third party is chasing you, and that leads you to trespass?
Yeah, I mean, I don't know how that's legally treated, but it certainly seems legitimate.
In the question, we see a lot of emphasis on the idea that there's an aggressive fish. Do you associate anything with that? Like, do you take away, like, intuitively anything from that?
Well, an immediate thought, like an immediate comparison I thought, is like if someone broke into your house and then your stairs did not meet code, they were dangerous. Or I don't know, there's your electric wiring isn't up to code and someone gets electrocuted while breaking into your house. But then I thought this isn't really like that, because being aggressive, if it's an inherent quality of this fish, that's just like keeping a dangerous, I don't know, it's a dangerous animal, but they're keeping it for legitimate purposes. Presumably they have safety measures in place so that people who are trained to work with these fish do not get harmed. So the fact that the fish is dangerous does not seem relevant to me, because it's just a quality of this fish, I guess. It's not like, I guess it could be argued, but we don't know from this, but it's possible they weren't doing enough to mitigate or to protect people from how dangerous this fish is. But this seems to me that this isn't actually functionally different from if these divers just started drowning in the tank and or hurt themselves on equipment in the tank or something else.
All right. And finally, what do you make about the specific reference here to strict liability? First of all, do you know what strict liability is?
Well, I should, because we talked about this. Okay. Let me try to rack my brains. No, I don't remember. It's something to do with torts. Oh, it means attention doesn't matter? Is that right? No. Fault doesn't matter.
Meaning it doesn't matter whether or not the person who caused the damage intended to commit the damage, did so via negligence, did so via imprudence, did so because they didn't respect a legal norm.
Right. So then there's no implication here. It's irrelevant if the farm had dangerous practices that were against what this would typically be or not, right? Because it's not about negligence. The other thing that stands out to me is that I feel like it's relevant that they're divers and they're diving there, because that sort of seems to take away a lot of the possible legitimate reasons you'd be trespassing, like running away from danger, helping someone. Divers implies not just that they're diving, but also that they have diving equipment. They've come there with the express purpose to dive. Of course, it doesn't say why, but I can't think off the top of my head of many. The reasons I think you'd be doing that is theft or sabotage or something. I don't know how trespassing law works, which maybe isn't even the relevant question here, but it sort of implies something about what the possible circumstances are, which for me makes it seem a lot less likely that they didn't come with criminal intent. And I feel like that should matter, like your criminal intent. If you've broken into my house and you cut your hand while punching through the glass to break into my house, that feels like surely I couldn't be liable for that, because you did this, one, with criminal intent, and secondly, you did something obviously dangerous that you had no good reason to do, good legitimate business doing, and that could have very predictably gone awry. And like diving into a tank with dangerous fish, sure, it's very good chance that they had no idea that the fish were that dangerous and aggressive, but entering an enclosure of farmed animals with the intent to commit a crime, assuming that's what's happening, it feels like you can't be surprised, and you can't argue that you didn't know that there could be dangers involved. That's how that seems to me.
So I'm going to read you the possible answers.
Okay. Then
I'll reveal the answer to you for the United States, and then we'll work through the French one. So don't click on the reveal the French answer yet, because
okay,
it's got to be a surprise.
No, I want to be surprised.
So remember, the question is which way the court is most likely under strict liability to rule. There are two possibilities then. either in favor of Jack or in favor of the divers. So response A is in favor of Jack because the divers were trespassing on his property. Right.
Mhm.
So trespass equals too bad.
So I'm pretty sure that's not true.
B, in favor of the divers because Jack is strictly liable for injuries caused by his dangerous animals, regardless of the divers trespassing.
Yeah, that also doesn't seem right to me because, again, like if I have dangerous equipment and it's got a sign saying authorized personnel or whatever, you need training for this equipment. Someone can't come in there, stick their hand in it, get their hand cut off, and then say that's my fault. Surely the fact that they were there without permission plays into this in some way. Although to be clear, I don't think it's because I don't think the trespassing is relevant.
So to summarize, you don't like A because trespassing is too absolute.
Well, it's more that I don't think that the trespassing is the relevant part here. I think A is kind of a trick answer where you I guess as a non-lawyer, you'd immediately think, oh yeah, because they were trespassing, committing the crime of trespassing, it's completely their fault, whatever happens to them. And I know that's not true. And then B, yeah, I don't like B because that seems too absolute in terms of I don't believe that Jack is that liable as that implies.
Yeah, so essentially A and B are both sort of imply absolute answers, and you feel that absolute isn't essentially rendering justice in either case.
Yeah.
Okay, so C, in favor of Jack if he can prove that he had posted adequate warning signs about the aggressive fish.
Yeah, that feels like it could be that one. I'll see what D says, but nothing sounds immediately wrong to me about C.
Okay, so D, in favor of the divers, but only if they can prove that Jack was negligent in securing the area where the aggressive fish were kept.
So so that's kind of sounds okay too, but I think it's not that one because I feel like we established that the fact that they're suing under strict liability means that negligence is irrelevant, at least to establishing whether it's a tort. So I think it's C, in favor of Jack, because if he posted adequate warning signs about the dangerous fish.
We're going to limit this to two answers, or I'm going to tell you which two answers are possible.
Yeah, well, I assume it's C and D, right?
No, it's only A and B.
It's goddamn fucking law.
I saw on the Reddit a lot of people falling for C and D, and it's completely understandable. But you need to exclude C and D for one reason and one reason only: strict liability. Why? Because C is what? It's an imprudence. D is negligence. Those are faults.
Okay. Jesus. So is it really B then? He's strictly liable for the injuries caused by his dangerous animals, regardless of the driver's trespassing?
No, it's A.
It's A. Really?
Yeah.
Wow. Well, I've just embarrassed myself in front of our listeners.
So to our listeners who have yet to listen to the opening arguments episode, the answer is A, in favor of Jack because the divers were trespassing on his property. The reason for this is because apparently there is case law in the United States that says you cannot, under strict liability, sue when there is trespassing.
Wow. At all?
Under strict liability.
Under strict liability.
Yeah.
Oh,
so
okay.
if we're talking about at-fault liability, that could be a different thing. Now, Here's the thing. Where is the strict liability here? The strict liability is what we call dangerous, or what Americans call dangerous activities. So essentially through the 20th century, what has happened? We've increasingly done more and more dangerous activities. I mean, hell, if we go back to the Industrial Revolution, we've not ceased doing anything that's not dangerous, right? Everything we've done is dangerous. And it's had consequences on people's lives, right? Cars are a great example. And so over the years, judges have increasingly recognized that there are certain things that are just so dangerous that we should say, well, the mere fact that you're doing it, you should assume all of the risks associated. It's typically referred to as the theory of risk. So if you're operating a nuclear plant, for example, obviously we want you to take all the precautions necessary to put good signage and whatever, right? But ultimately, if you hurt someone, it's, come on. And you cannot just say, well, he shouldn't have drank the nuclear waste.
Right. Okay. Interesting. I guess that makes sense. When you put it that way, that makes sense.
Here's the interesting thing, though. If the fish were not dangerous, there would be no strict liability because dangerous fish equals dangerous activity. Non-dangerous fish equals non-dangerous activity. Therefore, no strict liability under the dangerous activities idea.
Okay. Interesting. So to clarify, the idea with this is so if you're trespassing and you get hurt by something that is negligence, you can sue. Like the example I used earlier, if you break into someone's house and they have dangerous exposed wiring and you get electrocuted, you could because that you wouldn't be suing under strict liability. You would say there was a fault committed by them, even
Correct.
though you're trespassing.
The most emblematic example of this, Liam, is booby trapping.
Mhm.
You are a good fire-breathing American freedom lover, and you decide to booby trap your front door with a shotgun, such that if a burglar dare step on your property and open the door without your permission, they will be shot in the chest with a shotgun. The courts obviously rejected the idea that you can oppose to the victim the fact
Yeah.
that they were trespassing.
Yeah.
Because that is not normal. That is a fault. I mean, like, imagine if it was the police. Imagine the
Right.
police have a warrant and die because you decided to put a shotgun rigged to your door that automatically shoots them. I mean, that's absurd.
Mhm.
So, fault. Yes, you can. There's still margin of maneuver under fault.
All right, but how would this be different in France then? Let's talk about the French side of this.
Okay, well, first of all, I want to ask you whether or not you think between A and B, there's a chance that we go to B, or whether or not we stick with A.
In France.
Yeah.
So it could still only be A and B because those are the only ones that are strict liability.
That's right.
I think tort law in France is much more wide-ranging, and for that reason, I would be surprised if France had this thing where there can't be strict liability when you trespass. My assumption, based on what you've told me, is that France probably doesn't work that way, and so France, it's probably B, that Jack is strictly liable for the injuries.
Okay, and do you think there might be any other differences in terms of like what legally is relevant from the prompt?
Let me see. Nothing jumps out to me.
Let's start with the applicable law here. So, Liam, you want to click on the link I gave you for Article 1243 of the Civil Code?
Okay, making me do the simultaneous translation again. The owner of an animal or
he who makes use of.
He who makes use of it. Let me start over with that. The owner of an animal or he who makes use of one during the time in which he is using it is responsible for the damage that the animal causes if either the animal was under his care. No, that's not right. Man. Keep this in. I want the listeners to hear me struggling to read something in French for the first time and translate it to English as I read it. The owner of an animal or someone who is making use of an animal during which is under his usage is responsible for all damage that the animal causes, be it while the animal was under his control or while the animal was lost or had escaped.
That's right. Good job.
So that's interesting. One, it stands out to me as interesting that there's a specific article in the Civil Code about animals, that
right.
separating that from other types of dangerous things. And second is that second part of that, where if the animal has escaped or is lost and then causes damage, that is treated exactly the same as if the animal was under the person's control.
That's right. I think it would be fun if I have you read the version of this article in the Louisiana Civil Code. Because in case our listeners don't know, Louisiana has a legal system inherited from its time under France.
Yeah, I'd love if we could get someone on the podcast who's a Louisiana lawyer or Louisiana law student. So if anyone like that is listening, get in touch because that would be awesome.
So to summarize, we need 4 things in order to have strict liability under Article 1243 of the French Civil Code. We need a harm, an animal, an active role in the animal causing the harm, and custody over the animal. I'll tell you what each one of these are, and we'll see how you apply them to the case. Okay, Liam?
Mm-hmm.
So, as we already said, of those 4 conditions, fault is non-existent, which means that we are, of course, under strict liability. Now, a harm is an infringement to one's bodily integrity, material interest, or non-material interests. An animal is any animal, regardless of species, dangerousness, or domestication status. So there we already see a pretty significant difference between the French and American conception. And then an active role of the animal in causing the harm. So this is the causal link. So this is presumed from the moment in which an animal makes contact with the victim. So, for example, if a dog bites somebody, we presume that there's a causal link. But if the animal was instead inert or dead at the time the harm was caused, the causal link cannot be presumed, which means that the victim must prove that because the animal was, I don't know, in a certain position, that they tripped over it and therefore got hurt. They need to show that caused their harm.
Mhm.
All right. And then finally, custody over the animal is presumed to belong to the owner, as was clear in the article, thus excluding wild animals, knowing no owner. So properly wild animals cannot be owned. However, if you sort of appropriate a wild animal, even though you're not supposed to, typically that will be nonetheless considered, for this sense of the law, as you being an owner. And an owner may only escape liability if they can demonstrate that they had meaningfully transferred custody over the animal to a third party. Now, I want to be very clear. This is to do what? This is to protect the victim. So I cannot just say, oh, well, I gave my horse to a neighbor who I won't tell you who their name is or anything about them, but I gave it to somebody, so I wasn't the one who had custody over the animal while it bit you. This prevents people from essentially their dogs escaping, for example, biting someone else, and then them saying, no, someone else was walking it at the time, therefore it wasn't me. I don't know who it was.
Yeah.
In most cases, it's going to be the owner. Because imagine, for example, I run a horse riding farm. Yes, I give you the horse to ride around the farm, but you can't just do whatever you want with the horse. Because in order to show that custody was transferred, I need to have given you the usage of the animal, the direction of the animal, and control over the animal. So if I haven't transferred fully those three, there is no transfer of custody. So if I, for example, say, hey, Liam, you can use my horse to spend the weekend in Paris, just bring it back by Monday, custody has not been transferred because you aren't free to use it as you want, right? Because I still said, hey, it still needs to be back on Monday because, I run a horse farm. Okay. So let's, why don't you try applying it?
Yeah, well, right. So there was harm, obviously. The harm is the injuries. It doesn't say what they were, but they bodily injured caused by the fish. There was an animal. The animal, is actively involved in causing the harm because they attacked the divers. And Jack has custody over the animal. He hasn't transferred custody to anyone else. So it seems he's the owner, So it seems like there's pretty clear liability under French law. Seems like a pretty open shut case.
Yes, he is strictly liable. However, that is not the end of the story. There's two steps here. So first, we check the conditions. We just did it. The question now is, now that he is strictly liable, are there any grounds for exoneration? So French law allows for 2 or 3 main ways for, once liability has been established, for someone to then escape that liability, or at least a part of that liability. So there's a few ways this can be done. There's either grounds for total exoneration or partial exoneration. Total exoneration is a very high bar. It is when there's force majeure. Now, force majeure is when there is an unforeseeable, unavoidable, and external event, and that means external to the liable party, or when the act of a third party has those very same characteristics. Now, the other alternative is partial exoneration. So we're going to say, okay, you're liable, but not entirely, or at least you're not going to have to pay for the entirety of damages that were created by this incident. And this would be because the victim themselves commits a fault directly leading to the harm. Now, the deliberate trespass, of course, which is sufficient to constitute a fault, cannot, though, be considered force majeure. The reason it can't be force majeure is because is it unforeseeable that someone may at some point trespass on your property?
No, it's foreseeable.
Yeah. Is it unavoidable?
No. And as you said before, there's also legitimate reasons for someone to trespass.
It is, though, external, right? Like someone whose property is trespassed upon is not them, like they did not cause the trespass. It is not them who is trespassing. So it is external. So only one of the 3 conditions of force majeure would be fulfilled. Now, what do you think about partial exoneration?
Well, it sounds to me like this would be partial exoneration because the victims did commit a fault directly leading to their harm. They were, in terms of getting in the fish tank, I would think, right? Not or the fish pond or whatever it is. That seems to me to be the fault, not the trespassing. So it sounds like partial exoneration.
I would say it's probably both,
Oh,
actually.
really?
But yeah, so definitely some form of partial exoneration.
And what does partial exoneration mean?
It means that the judge can decide to essentially, based on percentages, decide that you are not entirely liable for the damages.
So does that mean you'd pay only like half the damages or something like this?
For example, yeah, if the judge says, "Oh, well, I think the fault of the victim it corresponds to 50% of what brought us to this situation," then they can reduce or they can exonerate up to 50%, for example. And this is especially going to be the case when we're talking about more like the burglary examples that you reference, where the judge is going to be like, "All right, 90%." You know what I mean?
Mm-hmm. Yeah. Does that have any? Is there any similar to that in U.S. law that you know of?
I understand there's something in the U.S. called comparative liability, but I actually don't think they apply that. Someone would have to correct me. Please do, by the way. But I believe that only applies to fault-based liability.
Mm-hmm.
So my understanding is that at least when there is strict liability, it's harder to, or maybe not even possible to exonerate. So essentially, the U.S. solution to this seems to be no, there's an exception to strict liability when trespass, whereas the French are like, well, let's let the judge figure it out whether or not you can kind of reduce your liability, but you cannot fully be exonerated in this circumstance. Now, we sort of touched on it, but there's a big difference here, which is that the American system seems to only want to extend strict liability to dangerous animals as opposed to animals generally. And this is actually a key difference because, as you may know, Liam, the cases of strict liability, or the instances in which strict liability can be invoked, are quite numerous in France. So we have liability for animals. We have liability for strict liability again for the acts of minors who have parents, and notably there's strict liability for damages caused by things.
Right, but it all seems to me like the American making a distinction between dangerous and non-dangerous animals. That could lead to a lot of just unclearness with what's a dangerous animal, right? Are certain types of are certain types of dogs dangerous? And which seems inherently correct that there would a big dog, a pit bull is dangerous, whatever, Chihuahua, maybe that's not dangerous. But that's just then you're cutting such fine distinctions if you're going into different types of different breeds of the same species, or
precisely. Now French law, there was a brief moment where they thought about going down the dangerousness logic. It's one that you find in many other legal systems beyond the US, to be clear. And it's attractive, right? So the logic that's given by American lawyers, at least the ones I've heard on this subject, is they say, well, when you go about your everyday life, say you walk your dog, you take precautions, but it's still a dog and it might bite someone. But when you have a really aggressive breed of dog, that's different. You shouldn't be walking so laissez-faire your dog around. You should be. So they see it as like a moralization thing, like dangerous. Well, there's different logic. Some people see it as a purely risk analysis, like danger equals risk, therefore strict liability. Other people say, no, this is supposed to encourage people to act as good citizens. And a good citizen takes more precaution when they have a more dangerous dog. But French doctrine rejected this because they said, well, but isn't that already achieved when you have strict liability for both aggressive, dangerous dogs and non-aggressive, dangerous dogs? Because if you have a dog that's more likely to bite someone, surely you're going to take more precaution because in any case, you're strictly liable. And if you have a dog that's less likely to hurt people, you're going to allow more risk because it's probably not going to happen anyway.
And obviously also the damages are awarded based on actual damages, right? It's not like a little nip from a puppy is going to be treated the same in court as the chunk of your leg's been ripped off by the, what were those pit bulls they banned in England? The XL, what was that called? The American Bully XL is the type of dog, the dog breed they banned in England for being exceptionally dangerous and aggressive.
That's a cool name. I like that.
It is a cool name.
That should be a rapper name or something. Imagine there's two scenarios here. You have a non-dangerous dog who bites your, a good chunk of flesh out of your leg. Yeah. And you have a dangerous dog who bites flesh out of your leg. Isn't it a little weird that the victim should really hope that the dog was dangerous?
Right. Yeah.
Like the idea that could fundamentally, like you're the victim of the same thing at the end of the day. But whether or not a judge at some point thinks that that dog is somehow a dangerous activity, it deserves compensation, and in the other case, doesn't.
Yeah. Yeah. It does seem weird. Did you want to mention your recent case with
No.
animal torts? No.
No. Maybe on another episode. I'm not ready for that now. We just brought the dogs to the vet, and they're all okay.
Oh, that's good. That's good.
There's a couple other interesting aspects I find about this. As an example, French judges are, by this solution, in some ways given more power and in some ways less power. So they're given more power in the sense that if everyone's sort of strictly liable for the acts of their animals, they can really take into consideration the specific facts of the case and decide exoneration based on their understanding of them and the evidence brought forward by different parties. But they also have less freedom because it's always going to be strict liability. Unless there's, total exoneration, which again is very rare.
Yeah, I mean, as we talked about on our episode about French tort law, you emphasize that an important aspect of it is that like the French generally just like make a lot more things liable, I guess, but that is counterbalanced by the fact that it is much more widespread that people have very broad liability insurance, almost universal. And so as a result, like if you had one of those without the other, if you just had more people getting made to pay damages without there being this widespread affordable insurance that's bundled into pretty much everyone's homeowner or rental insurance, it wouldn't work. It would be very unfair. So I feel like that's a big part of the reason why this stuff can sound unfair to Americans. Like it can sound ridiculous. But Jack or Jacques, why should he pay that? He did nothing wrong. His fish were properly kept. He did everything correctly, and people broke in and went diving in his fish tank, and they can now sue him. They now have grounds. He has to pay them out. But the thing is that at least in France, well, probably in the U.S. too, in the case of a business, Jack doesn't really care, right? He's not having to pay this. His insurance is paying this. I don't know. Maybe his premiums go up. I don't know if that's a consideration. I don't know how insurance works.
Now, I just went on a whole thing about why does it matter if the dogs are dangerous?
Yeah.
I mean, obviously, in this case, we're talking about fish. But I want to bring it to dogs because dogs are a particular case. The reason is because France does recognize a notion of dangerousness in dogs, but not from a civil perspective. In France, there are what are called Category 1 and Category 2 dogs. The mere fact of owning one of these is a risk, is a risk, and you must meet certain conditions in order to take this risk. So typically you need to have a special insurance if you have a dangerous dog, and you can be found criminally liable for certain acts these dogs commit. So this I don't want to say this is an exception to the rule, but it is pretty consequential. Do you know why? If your dangerous dog bites another dog, your normal liability insurance will not cover it because you need a special liability insurance for dangerous dogs because they're so likely to cause a damage.
Yes. By the way, I've checked this. The American Bully XL is a Category 1 dog in France.
I am not surprised.
It's not just the UK that's getting all woke and cracking down on the American Bully, the poor, innocent American Bully. XL.
This system sounds great because, we sort of get to have our cake and eat it too. We get to have a very protective, high insurance system for most animals. It works pretty well. And people who have dangerous dogs or categorized as dangerous dogs have increased obligations. They need more insurance. They need training. They can't have been convicted of a crime or something like that. Like there's a whole set of rules. They need to get a specific authorization, et cetera, et cetera. However, what happens, say in my case, you own 2 dogs who are bitten by a dangerous dog.
Mm-hmm.
What happens if that person did not get an authorization and does not have the special insurance? Well, you're dealing with the criminal system and you're relying on the fact that they have money to pay you. So in that circumstance, it's not always a great thing because, again, if someone's just breaking the law outright, you're not going to get your damage repaired through the insurance model. Unless, of course, they have their dangerous dog insurance. So 2 sides of the coin.
You might be incentive to conspire with with the trespasser to cover up the fact that a crime was committed.
You mean saying that it's not a dangerous dog? Being like, that pit bull looks like a cocker spaniel to me. So animals outside of like most animals are covered by the rural code, a code I know so little about.
I didn't know that was a code. That's great.
That is a code, yeah.
Does it just apply to rural area? What is that for?
Yeah, there's tons of stuff in there. It's wild. Old forms of like property stuff. I mean, it's
when you get out into the depths of the French countryside of the province, the law gets weird.
So to recap, very different solutions from a legal perspective, but in this specific case, I don't really think the outcome. I mean, it depends. It would be up to the judge, but there's a world here in which the outcome is functionally very similar.
Right.
But I would say ultimately France, I think we can see in this case sides more with victims.
Yeah, I mean, it strikes me as a good thing, like not knowing that much about it. The American thing where strict liability can't apply if someone was trespassing, that strikes me as bad. That strikes me as a bad way to do that. But I've trespassed a lot in my life, and especially when I was a kid, we used to,
That's a great point, right? Like I've heard people tell me stories about like trespassing at a rail yard, for example.
I don't know who that would be.
And I sort of side on the idea of strict liability for that because it's like, okay, if you can just easily trespass onto a rail yard.
Yes, that rail yard, by the way, has 0 fences.
See, you could go for a fault, right? You could say, oh, the trespasser needs to show that they should have put up fences. And we know how the court will decide. They'll be like, it's fine. You don't need fences.
Yeah.
I think, I'm sorry, if you want to save money on the probably millions of dollars of fences, you just, you pay out every time someone gets hurt. Who cares? Like, what does it matter to you? It's this idea that there are people who are jumping in front of trains so that they can get, again, their damage is paid for.
I've never heard I've never heard anyone make that argument about liability insurance, but I'm imagining it now. I like it, like that argument you hear about against like socialized healthcare, where it's like, oh, but then people will be going to the hospital just frivolous operations.
There are people who believe that people get in accidents intentionally in order to win a lawsuit, which is
like in Better Call Saul. They do. I saw it in Better Call Saul.
That is a real perception people have of how I believe that people believe that to be real.
Yeah, I think for a lot of people in the U.S., you especially see this with healthcare debates. A lot of like conservatives in the U.S., they're just against the concept of insurance. Like a lot of arguments you hear against socialized healthcare, or especially back when people are talking about that. Unfortunately, no one's talking about that now in the US, but
no, it's old
back
school.
In like 2016, 2020, you would hear the classic, or even before that, like during the Obamacare stuff, you would hear the classic, but why should I, a healthy person, have to be paying for a sick guy? It's like, well, that's just, you're not opposed to government healthcare. You're just opposed to the concept of insurance, which is fascinating because insurance is really, or not just insurance, but more broadly, the pooling of liability in different ways is literally the core of modern capitalism. Like it underlies all of it, and so being against that is very funny. It's such rugged individualism, of course, and like that's how, right? The limited liability company is the foundation of modern capitalism.
You should read it at some point. I have under primers but I would call it like a pseudo like primer to like a theory of tort law, kind of like a political theory of tort law.
And to our listeners, we do plan to put that kind of thing up on our website at some point, right?
Oh, absolutely, yeah.
So that will hopefully be there by the time you listen to this. Although, well, go see it for yourself. If it's not there, you'll find other great things, I'm sure. Right. But to go back to the trespassing thing, I mean, a caveat is that I come at all this stuff from a non-legal perspective, right? A non-legal mind perspective. So I tend to just think of these things as like, what seems fair? What seems intuitively fair? Which, to be fair, I feel like that's the basis of a lot of law. Fundamentally, is judgments about what seems fair. It's just that those judgments are made based on, I suppose, principles. But still, a lot of it, especially I feel like in the American system, does come down to like, what would a reasonable person think is reasonable here? Trespassing is such a minor crime. Like the penalties for trespassing, in most cases, are so low, and the idea that trespassing should waive your right to strict liability, seems like it comes from just sort of like this, again, this attitude I feel like you get in a lot in the US, which is this attitude that like if you're committing any sort of thing that's not right, that's not strictly legal, you're a bad person. But like, yeah, I have trespassed so many times in my life, especially when I was a kid. I grew up, for listeners, I grew up in the middle of nowhere and there wasn't a lot to do. So we used to, like when I was in middle school, we used to all the time at recess sneak out of school and just trespass for fun. Like we used to, there was like a, what do they call it? Yeah, like an auto works store across the street. And we would go over there and try to sneak around it and have them not see us around these big, like, piles of, I don't know, salt and stuff. Or we would just go into the suburban area and run across people's lawns and hope they didn't see us. And the idea that like if we got hurt as like 11-year-olds doing that, there wouldn't be strict liability. That seems ridiculous, right?
If you don't want people on your land, you should have to put effort into making it private. Like, you want to be free to leave glass all over your backyard without kids getting hurt when they run across it. Put a fence. I'm always in favor of victims here because ultimately, all a victim gets is their damage repaired. That's it.
Yeah.
Nothing more and hopefully nothing less, right? And so by the time you're in court, you're not there for fun. Let's be real. People don't, 9 times out of 10, somebody gets hurt. It's a $2,000 medical bill. They might ask you nicely to pay it. You say no, they'll eat it.
Yeah, right.
That's the reality.
Since I'm visiting my home in Maine right now, I thought of this, that Maine actually has, it's only trespassing in Maine if there is a posted sign saying saying that people are not allowed in this land. Like the default assumption is that you are allowed in any land. Not only that you're allowed there, but that you're allowed to hunt and fish and do anything that's considered like non-destructive of the land, like that, camp there. I think the main impact of that is causing a sort of visual annoyance that if you go into any rural area in Maine, it's just littered with signs. Yeah. It's like these, you must have seen it here, and you definitely don't see this in other New England states, that's for sure. But it's like every, I don't know, 100 feet. I'm not sure what exactly it is. There's like the same sign over and over again all along roads. Because otherwise, yeah, and a big part of the reason people do it is about hunting, right? Like my parents, for example, they don't care if someone's walking through the land.
Yeah, they just don't want someone to hunt.
They don't want someone to shoot, obviously. Like, and not even as like an anti-hunting thing. It's more just like, I mean, you know what hunters are like in the U.S. There's not a lot of, especially in Maine, where there is no gun licensing required. I mean, you do need a hunting license, but it's really, really easy to get. There's a lot of irresponsible people out there, and there's been some cases where people got in Maine where people got shot by hunters, and the courts ruled in favor of the hunters. Let me pull up this case. There's this famous case in Maine, the 1988 death of Karen Wood. On the morning of November 15th, 1988, Dr. Kevin Wood never felt better. He was up, showered, and changed, anxious to get to his new job. Sometime after 3 p.m., Karen laid down her tools and put the babies behind the child gates in the living room. Outside, bright sun shone through bare trees, but the air was Halloween crisp. So she put on her dark blue jacket and pulled on a pair of white mittens. That's relevant that she was wearing white mittens.
Oh, no.
Because you know who else sort of wears white mittens? Deer. I'm serious. She stepped out of the glass of the deck that overlooked their acre-and-a-half scrubby wood. She went down the steps into the fenced-in dog kennel that extended 100 feet beyond the deck. She opened the gate and stepped out. In the clearing, some 63 yards from Karen, Donald Rogerson, a hunter well-known in Bangor sporting circles, raised his rifle, took aim, and fired. He lowered the gun, pumped another round at the chamber, and once again pulled the trigger. Basically, Karen was shot dead by this hunter. The hunter was arrested and taken to Bangor jail. Because her death was related to hunting, game wardens rather than police handled the investigation. That's kind of weird. In the letters and guest editorials to the Bangor Daily News, though many sympathized with Karen, some readers took issue with the fact that she was wearing white mittens and why she wasn't wearing blaze orange, as everyone who lives in Maine knows well enough to do during hunting season. It was the task of the grand jury to determine on the basis of evidence not whether Rogerson was guilty of the crime of manslaughter, but whether there was sufficient cause to suspect that the crime may have been committed. Manslaughter is defined as causing death through conduct that is either criminally reckless or criminally negligent. Under Maine law, the proceedings of the grand jury are secret, and the identity even of the numbers of members of the grand jury are concealed. So what was presented in that session may never be known. Whatever it was, the grand jury decided not to indict Donald Rogerson for manslaughter in the shooting of Karen Wood. And again, it wasn't known what exactly happened, but a lot was made out of the fact in the press that she was wearing white gloves and wasn't wearing orange. So pretty crazy case. I mean, I guess it never went to court, but
yeah, but to me that's criminal liability is what we're talking about there.
But still, I mean, she was right in front of her house. Yeah, he did. It does say here that the widower brought a case against Rogerson for wrongful death, which was a civil suit and was therefore paid out by his homeowner insurance.
But by the way, just real quick, did you speaking of guns and things you shouldn't do with them, have you seen this video?
Teen rapper accidentally shoots himself dead while filming video. Jesus. Okay, let me play this. I'm watching a Bitcoin ad. No, they still did that. What the hell? The New York Post not show the part where he... I get the idea, but I didn't see the part where he actually shot himself. That might be for the best.
It's pretty horrific.
Yeah, that's insane.
But also, how does this 17-year-old kid have a gun?
Is that legal? I'm not sure. In New York? Was it in New York?
No, definitely not.
I mean, you can...
Not a handgun?
I know that's legal here in Maine. Probably not a handgun, but you can get a gun, but when you're younger than 18.
Nonetheless, it's horrible. I mean, Jesus Christ.
Gun culture in the U.S., that's a whole other thing. And I tend to have a kind of contrarian view on that, where I think people make too big of a deal out of it. I'm glad I live in a country where it's not like that. Let's say that. I'm glad I live in a country where it's not like this, and it's not something you have to worry about, because it is like, that shooting that happened here in Lewiston, Maine, a few months ago.
Yes.
That kind of stuff is horrifying, and the fact that it happened like in Maine brought it sort of more down to earth. And I do find myself thinking now when I'm here and go to a crappy bar or whatever, it's just like it's pretty alarming that someone could just do that. It would be so easy for them to do it anywhere in the US, or at least in Maine. And that does seem bad.
We will definitely be doing an episode on gun laws at some point.
Oh yeah, that will shock the American audience. They will be up in arms, cursing France for its lack of freedom when they hear how gun laws work in France, which are relatively actually, it's a lot easier to get a gun in France than in like a lot of European countries, like England, for example, where it's very, very difficult.
Yeah. All right. Well, that's it for this episode. Thanks to our listeners for listening.
Yeah. Thanks, everyone.
We'll see you next time.
Bye, everyone.
Bye.
La France est une chose, à mes yeux, très considérable. Je me fais en effet de la France une certaine idée. Je veux dire par là qu'à mon sens, elle est quelque chose de très grand. Je me fais en effet de la France une certaine idée. Il y a même là quelque chose d'extraordinaire. Je me fais en effet de la France une certaine idée. Il faut que la France joue son rôle, c'est exact. Et pour qu'elle joue son rôle, il faut qu'elle soit la France.